CV21 is now in session.
Thank you. Please be seated. This is the time set for oral argument in Lomeli versus Velasco. Our case number is CA-CV21-0576. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, you'll need to keep track of the time using the podium clock. We will not keep it for you. Out of respect for counsel, I would ask for those in attendance to make sure their cell phones are off or on vibrate, and that also will help avoid embarrassment as well. Two, we've read the briefs, conference the case. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube, so please, as you begin your argument, state your name and the party that you represent. With that, Mr. Schwartz.
Oops. May it please the court. Good morning, members of the panel. Stephen Schwartz on behalf of the defendant or defendants and appellants Jessica and Philemon Velasco. Your Honor, Your Honors, the powers of the court under Rule 60 to grant relief from judgment improvidently granted has been described as a grand reservoir of equitable power to do justice in a particular case. The Velascos are here asking this court to exercise that power to grant relief from a judgment tainted by acts, omissions, and error that would make allowing the judgment to stand manifestly unjust. The plaintiff in this matter engaged in reprehensible acts constituting a denial of due process in order to obtain an order for alternative service. Mr. Lomeli represented to the court that the Velascos were deliberately avoiding service, which was untrue, and which was unfounded and without evidentiary support, and presented a facially false affidavit of service. In order to obtain a default judgment, Mr. Lomeli represented to the court the Velascos, address, and an incorrect address, making all motions, pleadings, and orders that followed be sent to that incorrect address as well. Mullane versus Hanover instructs us that when notice is a person's due, process which is a mere gesture is not due process. The means employed must be such as one desirous of actually informing the absentee might reasonably adopt to accomplish it. And that, in short, is what the case is about.
Counsel, let me ask, you had mentioned that you're invoking this court's equitable power, or the court's equitable power to set a judgment aside. Did I hear that correct?
Yes, Your Honor. Rule 60 is equitable.
Right. And given that, what deference is owed to the trial court's decision after an evidentiary hearing?
And counsel and I have been discussing that because that really comes down to the proper standard of review is here. So I think there are multiple standards enunciated in Rule 60 because it's now a conglomeration of former rules. So in this case, because voidness is the issue, a de novo standard applies according, at least that's not just my argument, but also I'm taking that from Ezel, which, let me give you a quote on that. 224 Arizona 532, 536 to 537. And this case, Ezel versus Kwan, was not only cited by Blair, but also Blair versus Bergener, but also was referenced and argued in the appellee's brief at page 10. So Blair, interestingly enough, Blair addresses a number of cases in talking about what the standard is, but every case that it lists for the standard, well, none of the cases it lists for the standard are cases involving the argument of voidness for insufficient service of process. So what we ended up with in Blair cites Ezel versus Kwan, which was a partnership fraud case, but service was had in that case, and it was a default. Goglia versus Bodnar, which is a medical malpractice case. Dow versus Harris, which we're all familiar with, was also medical malpractice. And Corbin versus Marshall, which is a security frauds case. The one case that was referenced in Ezel was a case called Miller versus National Franchise Services, Inc., 167 Arizona, 403-407, and there was an issue raised of voidness. But the voidness issue arose after service. That was a case in which the defendant had filed a bankruptcy petition and claimed that his default was void. So in every one of those cases, there had been proper service. Now, Ezel does have a quote, and I don't mean to abuse the court's time or take too much of mine, but Ezel says at, 224 Arizona 532, 536 to 537, generally, we uphold a trial court's denial of a motion for relief under Rule 60C absent a clear abuse of discretion. Seems to suggest something. And cites a case. And goes on to say, a court abuses its discretion when the reasons it gives for its conclusions are clearly untenable, legally incorrect, or amount to a denial of justice. Still sounds the same. Then it goes on to say, we review de novo, however, the denial of a Rule 60C4 motion to vacate a void judgment, and cites Department of Economic Security versus Burton, and then goes on to say, when a judgment is void due to lack of jurisdiction, the court has no discretion, but must vacate the judgment.
What are we to make then of the post-judgment evidentiary hearing over the course of 3 days that involved conflicting evidence, but that ultimately the trial court resolved those conflicts in a way to conclude that service had properly been effectuated?
Well, I don't know that that the court made that specific determination because there were other issues that the court was addressing. So the court was looking at the question of, and frankly, the evidentiary hearing wasn't completed. So what happened is there were 2 days of evidentiary hearing, and they were maybe an hour at a, it was interspersed because the court's schedule was so busy. So there were partial days, hours of evidentiary hearing, and then the court at the end of the second day of that asked counsel to brief the question of whether or not, of waiver. And the judge at the end said, gee, I'm not really convinced, I'm not finding anything. But what I make of that is that that judge reviewed another judge's work. That was not the trial judge. The trial judge that issued the order granting alternative service was Judge Mackey, and reviewed his fellow judge's opinion and wasn't willing to overturn it. But that is not, I mean, his review may have been de novo, but the other question I have, well, the question I think that we need to address, or I'm addressing, is it's almost a so what. What we found was that there was simply no there. There was no attempt to serve.
Well, can I interrupt for a second, counsel?
Of course. Judge.
Because the question is, how do we treat this? We have a judge who did an evidentiary hearing, made findings of fact, and then we have our standard of review. And it seems to me when I look at the Lukoski case, we made it very clear, look, it's still a de novo review, but we're going to defer to the Superior Court's findings of fact because of that evidentiary hearing. So we're going to take the facts as the Superior Court found them, but do a de novo review from those facts.
And I think that's fair. I think that's exactly the correct reading. And I think that accepting the Superior Court's, if we call them findings of fact, I don't know that the Superior Court didn't actually find fact. We know from what the Superior Court determined that it did not determine to invalidate the
Right.
So if the Superior Court didn't make factual findings, we have no deference. We just really are doing a de novo review.
And because the Superior Court does not make specific findings of fact, I think that's the position we may find ourselves in.
Were specific findings of fact requested?
No.
Okay. And
No,
what's
and-
your best authority that the Superior Court needed to make them in this case?
I don't believe that Superior Court did need to make them.
Okay.
I think that what's fair here is to look at the record, because I think the record establishes that, I mean, obviously, findings of fact with regard to the process server, the process server's attempts are relevant, but they weren't relevant to the initial determination of impracticability, because the judge didn't hold a hearing. So in other words, what we have here is a judge who errs originally when he receives a motion that certifies in the motion that there's a deliberately avoiding service. So
is your position that the trial court is always required to hold an evidentiary hearing in
No.
that context?
I don't know that the trial court was required to hold it. The trial court, sua sponte, set the evidentiary hearing.
Well, in the challenge to the judgment, I'm talking about the initial impracticability certification.
No, of course. If you have a circumstance where the affidavit of the process server is sufficient, then there's no reason to hold necessarily a hearing. And I think
In fact, such a hearing would be an ex parte hearing. It would be
it would still be
largely a
ex parte.
waste of time.
However, what we are cautioned about is that it is the court's obligation to protect the rights of the absentee and the due process rights. So the argument here is that didn't happen here. Instead of looking at the documents that was before him, the judge in this case,
Judge Mackey.
Judge Mackey in this case, accepted those documents as true and correct, and they weren't, both with regard to what the process server filed, which was facially invalid. The process server says she attempted to serve a property on a specific date and time, and then had filed her affidavit before that date and time.
I thought Judge Mackey, or Judge Napper, I'm sorry, had found, or at least stated, there's outside information that confirms what was in the process server's affidavit.
I'm just not.
I'm reading from the transcript on the 10th of September.
So what the issue that arose during the hearing was that there were multiple gates on the property, and the process server referenced only a single gate. My clients claimed that one gate was always locked and one gate was always open.
And there's inconsistent testimony from law enforcement, right?
Yeah, and from neighbors. I don't think any of that is really relevant, though, because what's relevant is what steps were taken. There are two relevant issues to, at least to my appeal. One is whether or not the plaintiff, whose obligation it was to show impracticability, did so. And my point of bringing forth the discussion about Blair versus Bergener, 4.1K, all these other things, is to be clear that there was no communication or even attempt to communicate with the defendants in this case or anyone about them. It was merely a drive-by. According to the testimony, and that's why I'm saying this isn't about credibility, the process server herself says, I try to spend 2 to 5 minutes when I go to a property.
Can I?
Yes.
Counsel, so are you just saying facially it was invalid? we don't need to listen to any of the testimony, because it seems to me that's what you're trying to argue, is that the issue is Judge Mackey, when he saw this request, should have denied it on its face.
Well,
Because how do I get anywhere but it's okay, at least for Judge Mackey, unless you're making that challenge?
Judge Goss, at the risk of putting my foot in it, I think that the job of a judge in that position is to protect the rights of the absentee by reviewing the documents, and then, if it's appropriate, having a hearing clearly with the
So you're saying that facially, this was so inadequate that Judge Mackey should have held a hearing?
Absolutely.
It's a facial challenge?
Absolutely. Absolutely.
So
Because...
what should this...
Go, I'm sorry.
What should the person have put in the affidavit to survive it? Because this seems like a fairly standard affidavit.
It's not what it's what the person should have done, which is, if you look at every other case in which we're looking at impracticability, there's more than just a drive-by. I mean, I think we've probably all spent more time in fast food lines than this process server spent trying to sit outside the property.
Does that change, though, when you've got a locked gate? I mean, we see these all the time where we're in a place where the gate is for the community, and there's never going to be a way to access that. So if you've gone twice and see a locked gate, regardless of whether there was another gate on the property that maybe if you'd driven the property you could have discovered, but when you're encountering a locked gate,
right,
what is staying there until someone comes in or out? I mean, what should that person do in that circumstance?
I think the guidance is provided by the cases that I've referenced for the court, the federal cases, those district court orders, where what happens is, if you can't serve the person at their home, you make inquiry as to where you may serve them. You know, there was not even a phone call here.
But can I ask,
Yes,
I thought at least at the evidentiary hearing, you mentioned a drive-by, that the process server, and I get that there are two houses, and I think this is reference to what I've referred to as the Paulden house, that the process server went there 3 times, was unable to access any other entrances, either locked or blocked, no trespassing signs on all, left the card each time they were there, and they was unable to get in, and each time when the process server went back, so 2 times, the card was gone.
Right.
Well, and I'd add to that, I think there was a beware of dog, and the process server honked the horn to try and get attention of the people in the house.
Which, again, was not in the notes the process server testified to, but assuming the credibility of the processor. But assuming the credibility of the process server, then we have the issue of the process server's perjured statement in the affidavit. So I don't know. Then we get back into the credibility.
So what is it that you say is absolutely perjury about her statement?
It's a false statement under oath. She states that she attempted to serve process on the vacant house. So she went 3 times. The first thing she did was she was sent by the plaintiff to the house that was being foreclosed.
Right.
There was no one there. It was a vacant home. It happened to be right around the corner from the office, so it was probably very easy to go to. But what she claimed, and I do need to give the court a core agenda, but what she claimed in her affidavit was that on December 18th at 3:15 p.m., she went to that house and attempted service. Well, she filed the affidavit at 9 a.m. on the same day. So clearly there was something that could have rung an alarm bell. The other thing is that
was that point raised at the evidentiary hearing before Judge Napper?
It was, but it wasn't raised at the evidentiary hearing. It was raised when I was making my proffer at the end because we never got to an argument.
I thought the process server had testified.
I'm sorry, and the process server did testify, so it was raised. And the process server had an explanation for it, which was maybe I made a mistake, or maybe the court hadn't changed its, it might not have changed its date thing. But again, what we're dealing with was 3 documents that the judge had. A return of service on the vacant property, which had a mismatched date, a return of service saying I can't get into the gate 3 times, which, by the way, over Christmas, one time was at sunset, one time was at sunrise, and one time was in the middle of the day over the Christmas, New Year's holiday. So,
But she also said there were cars there and lights on.
yeah.
It's not like she attempted to serve somebody who was on vacation.
So right, so that's the point. She knows somebody's there. So what we see in these other cases is an attempt to contact a neighbor. Longo, which is a case that I referenced, they go over and check with the neighbor. Is that the house? Do you have a number? Is there a way I can contact them? Every one of the cases that we have referenced, that we have a record of showing alternate service challenged and either granted or denied, there's much more than there is in this case.
And why would she need to do that if she had the right house? I mean, it's not like going to the neighbor would have changed this. She was at the right house.
Well, it's not that going to the neighbor would have changed it, but she may have been able to communicate with the neighbor. She may have been able to communicate with the Velascos by either using a telephone or by using a neighbor to make a call. The whole point of the due process, I'm out of time, but the whole point of due process, if I may finish this sentence, is to provide notice to the person who is absent. And that didn't happen in this case.
Thank you, Mr. Schwartz.
Thank you, Your Honor.
Mr. Lindy.
Good morning, Your Honors. Please, the panel, Lawrence Lind, on behalf of the intervener, House Opley, LLC. In preparing to argue today, I thought the best place to start might be to talk about the fact that this case started 9 years ago. It started in 2013 when the Lomelis didn't pay their property tax for the first time. And the property tax statutory scheme provides a system to compel taxpayers or property owners to pay their property tax. It takes years for this to unfurl, years. And the homeowner or property owner has to literally ignore their obligation to do this through an entire series of legal proceedings. And unfortunately, for the appellants, that's what they did in this case. It takes a year for the certificate of purchase to issue. It takes 3 more years before a foreclosure can be begun. Pre-litigation notice, lawsuit, attempts at service, default pleadings, entries of judgment, and in this case, the November 1, 2019 certified letter, which was actual notice that the judgment had been entered and that we are going to sell this house to satisfy it if you don't pay the man his costs. And all of these were ignored. So that's why these defendants lost their home.
I'll just jump in on something I think is fairly straightforward, but one of the arguments is the address was wrong. It included I think 5 numbers at the end. Any evidence in the record that any of those mailings were returned in particular to the court when the court used that address?
None whatsoever, Your Honor.
Okay.
No mail was the testimony. No mail was returned to Mr. Lomeli. No mail was returned to the process server when, at the time of the posting the following day, she mailed it. And no mail was returned to the court. So no indication at all that any of this mail was not received, which is the legal presumption. And that was what I believe the court found as well, if not explicitly, then implicitly. On the standard of review, and I know that counsel talked about this and the court talked about it, I was a little bit intrigued, if you will, when I saw in counsel's brief that the court reviews whether personal jurisdiction is obtained is reviewed de novo. And so I looked, and sure enough, the DODEV, I'm going to pronounce it DODEV, I don't know if that's how you say it or not, case said that, but you keep reading for a few sentences, and it says the Court of Appeals will defer to the Superior Court's factual findings as to whether there was proper service and will not set them aside unless they are clearly erroneous, which suggests a clearly erroneous standard. Appellants argued in their brief, and I agree entirely, that service of process, alternative service of process, granting it is a fact-based ad hoc determination. And I think that's correct. I think by definition it has to be. And in this case, or in the Dodev case, this court said we're not going to set it aside unless that decision was clearly erroneous. And just to further complicate matters a little bit, there's a third standard of review, I believe, that comes into play, which is a denial of a Rule 60C motion is reviewed as an abuse of discretion. So there we have it. But in Blair, this court said that this court, meaning the Court of Appeals, will not second guess or substitute its judgment for that of the trial court. I'd like to turn now to some of the evidence that was given at the 2-day, 3-day hearing. The process server testified at some length. There were the 3 attempts at service at the property address, which is reasonable, given it was the one being foreclosed. Her cards were still there when she went back because no one was at the house. And this is not in the proof. There's 2 things. She actually had her proof of service, which was filed with the court, but then she had contemporaneously written hand notes as well. And so the facts of what she did were exceptionally well documented.
Is that the house, at least in my mind, that I've been referring to as the Prescott house as opposed to the Paulden house? Is that the house you're talking about?
Yes.
Okay.
On McCormick.
Because there are 2 houses, and I want to keep them straight.
Yes. And then we have the proofs of service at the Paulden residence, which reference the gate being locked, can't enter the yard, left our card, it's gone when we come back. As came up in counsel's argument, there was saw cars, couldn't see the license on them, saw lights on, left business cards, honked the horn. To call this a drive-by is just completely inappropriate, and I think it's contrary to the evidence. And then we have the testimony of the 2 officers, or sergeants.
Before you go on, counsel, because she talked about, and there's been some evidence that maybe one of the gates wasn't in fact locked, it was just chained. Is there any case that says a process arrest go up and try and remove a chain to get into a residence?
I'm not aware of any case, and I don't believe any was cited at the trial court or in the briefs. That was what...
It seems a rather extreme thing to do, expect a process server to check to make sure every lock is locked before they say the gate is secured, maybe.
We certainly agree, Your Honor. And in this case, Ms. Peschel went there 3 times. And you know, I don't know if she testified she shook the gate or not, but she honked her horn and did a number of other things. There was actually testimony about, even if there's no trespassing, it surprised me that process servers will still try to serve process if possible, because I probably wouldn't. But anyways, that was what the testimony was. Appellants called Sergeant Ethan Stouffer, noted chain and lock on the defendant's gate on multiple visits to the Paulden residence, was his testimony. Sergeant Michael Lewis, driven by the Paulden residence thousands of times, the likelihood of the gate being locked was great. And so the evidence in support of the fact the gate was locked and you couldn't get in, and you couldn't get to the house to knock on the door and serve these people is really quite significant. And the court found it credible, and it upheld the judgment. We could talk about the impracticability standard. This court in Dodev said extremely difficult or inconvenient. In Blair, this court said you don't have to show a complete inability to serve because the address is not known or the defendant has completely avoided service. And in this case, we have 6 attempts at service over a period of I believe it was 2 weeks. And Mr. Lomeli's motion said I think they're evading service. The court read the same thing, Judge Mackey read the same thing, and his order also found that it was an evasion of service, and the process service, Ms. Paschal testified, that when her card was gone, that's an indication that they could be evading service. And so nothing is clearly erroneous here is my argument. There is no abuse of discretion, and we have not one but two trial courts that found this. And in this case, I mean, Judge Napper went above and beyond in terms of allowing evidence and people to be called, and significant evidence was adduced. So the alternative service was warranted, and it was granted. Judge Gass, you pointed out earlier, and I think it's the most important fact in this case, is that the applicants lived at the Paulden residence. This is undisputed. There's no need to skip trace, no need to search for alternative addresses, no need to hire an investigator to find them, no need to go speak with the neighbors, gee, do they live here? They were there. The lights were on, the cars were in the driveway, and they testified that they were present and that they had lived there for many, many years. And so some of these other cases that were cited where, you have to do skip traces and find them, these sorts of things, just don't apply. That's a terribly important fact to this case. The November 1st, 2019 letter, and I don't think this court needs to get there. I think that there's adequate evidence that there was nothing clearly erroneous by the trial court. But if you do, there has to be some standard here for estoppel by conduct of a judgment debtor who claims that service was void, but gets this notice that was sent to the appellants that told them the judgment has been entered, there's a notice of a sheriff's sale in 46 days, if you don't pay the judgment, we're going to sell this house. And they still didn't do anything. So
And is that the notice that Mr. Velasco signed for?
it was. It's the certified mail that he signed for and testified he left it in his car.
And I understand your point, but all of that came after the entry of judgment, right? So either the judgment was righteous or it wasn't.
Yeah, well, and we make the argument that under the restatement and the Kaplan case that even a void judgment can have life breathed into it if a judgment debtor treats it as valid or doesn't do something that would require a reasonable person to step forward. And my argument simply is that this is actual notice. This isn't mere silence, acquiescing by silence. This is specific actual notice. So if the court gets there, I think that the judgment should be upheld based solely on that basis. There were other arguments raised. There was no redemption in this case. The appellants filed their motion to set aside, granted a short period of time, days before the 6-month redemption ran.
And they filed, just for clarity, in June of 20, right? After we just finished talking about this notice in November of 19. Does that sound right?
Yes, and the sheriff's deed was to be issued, I believe the 180 days or 6 months ran on June 19th, or 4 days after they filed, but they could have paid the redemption and saved it in that fashion as well, and they didn't. And at that point they had counsel and they had moved to set the judgment aside, so they certainly knew about it at that point. I also wanted to note in the file, the Superior Court file, and I didn't raise this in my pleading, but it's in the file, when the appellants filed their motion to set aside the judgment, which is documents, I apologize here, index of record 23 through 30, Mr. Velasco filed an affidavit, swore under oath that he never received anything in the mail about the judgment, and of course we know for certain that he did because he signed for certified mail. There's also excess proceeds, a significant amount of them, that are sitting there for the appellants. And so it's not like they lost their house for $1,000. This is the process, this is a statutory scheme. In a way, it's unfortunate that appellants acted as they did, but there's no clearly erroneous findings of fact in this case. There was no abuse of discretion in declining to set aside the judgment. Judge Mackey's order approving alternative service was based upon 6 attempts at service, and it was clearly inconvenient. I mean, it met the impracticability standard that this court has laid down in Blair and Dodev, and the trial court should be, both of them, should be affirmed in this case. If the court has any other questions, I'd be happy to respond.
Thank you, Counsel.
All right, thank you.
Counsel, we appreciate your presentations today. We appreciate your briefing. We'll take the matter under advisement, and we'll issue a written ruling in due course. Court stands in recess while the courtroom is being arranged for our next oral argument.